So we're on the record in docket 24010952. That is people of the state of Michigan versus Gregory Taylor. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Etheridge.
Good morning, Your Honor. Attorney Derek Esposito, the public defender on behalf of Mr. Taylor. Mr. Taylor is in the courtroom standing to my right.
And sir, you are Gregory Taylor, is that correct?
Yes.
Thank you, sir. This is the time set for preliminary examination today. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. It's my understanding that this is going to be an unconditional waiver of the preliminary exam from the defendant. The people also unconditionally waived their preliminary exam. And there is an offer on this matter that has been extended by the circuit court attorney, Jess Shaw. And it's my understanding that Mr. Taylor intends to take that offer in circuit or potentially continue negotiations.
All right. Is that a fair statement, Mr. Etheridge?
Yes, it is, Your Honor.
And at the very least, negotiations are to continue and there is an offer that is made. Is that correct?
Yes, Your Honor.
May I inquire of your client, Mr. Taylor, of his waiver of the preliminary examination?
Yes, Your Honor.
Mr. Taylor, you understand you have a right to a preliminary examination today. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by Attorney Derek Etheridge, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It's my understanding it is your wish today to waive your right to a preliminary examination today. Have this case continue in circuit court. There's been an offer made and negotiations are to continue, or negotiations are to continue. Is it your wish today to waive your right to a preliminary examination today?
Yes, Your Honor.
And Ms. Wilson, that the people also waive their right to a preliminary examination?
We do, Your Honor. Thank you.
Okay, I find that the waiver of the preliminary examination to be knowing, voluntarily, and accurately made. And I will provide Mr. Etheridge counsel the bind over documentation for signature.
Honor, if I can approach.
You may. Thank you, Mr. Etheridge. So I'm in possession of bind over documentation on docket 24010952. Defense attorney and counsel and the prosecuting attorney has signed the document. I will indicate that the examination was waived on today's date. That's July 19th, 2024. Before I sign the bind over documentation, is there anything else on the record in docket 24010952, Ms. Wilson?
Not for the people. Thank you.
Mr. Etheridge.
No, Your Honor. Thank you.
All right, I'll sign the bind over documentation. Mr. Taylor, your time in district court is done. You'll get your next, you'll get word of your next appearance from your attorney, Mr. Etheridge. All right, sir? All right, thank you. And that's all for the record on that file.
Thank you, Your Honor.
Would you like me to grab Mr. Rush?
Next.
If Miss Wanji's down there and she's ready, then yes. Otherwise, I think we're gonna need to wait until we know what she's doing.
When you go, so when you go down there, make sure you
They're in
know.
the meeting room. I saw them.
Okay.
Okay.
And then next, I think we can go on Mr. Labrie and Mr. Crino and I cannot remember Mr. Cornish.
Mr.
Cornish
Cornish.
is ready. I'm sorry, I completely blanked.
You know, Mr. Cornish here.
The head honchos.
I don't know if that's their actual name, the head honchos. I don't know if they answer to that.
Oh,
They
do
Do they, Mr. Abbott?
El Conquistador.
All right, so we're on the record in docket 24011532. That is people of the state of Michigan versus Brandon Labrie. Will the parties please introduce themselves for the record? Mr. Crino.
Your Honor, good morning. Assistant Prosecutor Bill Crino on behalf of the people of the state of Michigan.
Mr. Cornish.
Good morning, Your Honor. May it please the court, Deputy Chief Public Defender Steve Cornish on behalf of Mr. Labrie, who's appearing before the court via Zoom.
And sir, you are Brandon Labrie, is that correct?
Yes, Brandon Legree, correct.
Thank you. And you can hear me all right, Mr. Labrie?
Yes, I can hear you fine. It's just a
All
little
right.
hard to talk, because
Oh.
the with the water I was drinking, it's a little sore on my throat. So
All right, we
I'll
can hear
do my
you just
best.
fine. All right, thank you. And then Miss Bingham, you're here from the public defense, so you're the social worker at the public defense firm, is that at the public defender's office, is that correct?
Yes, Your Honor. Thank you.
All right, Mr. Crino, we're here on a competency review hearing. Mr. Crino, how are we proceeding today?
Your Honor, thank you. As the court has correctly noted, we are here today for a competency hearing. The defendant was previously referred to the Center for Forensic Psychiatry for a competency evaluation. Your Honor, a report has been prepared and received from Dr. Lisa Anaker, MD, at the Forensic Center. That report has been provided to the court and to all counsel in this case. Your Honor, my understanding is that the defense will be stipulating to the content of the report this morning. Your Honor, we would ask that the court adopt the recommendations set forth in the report, and we would ask first that it be admitted into evidence as People's Exhibit number 1 for the competency hearing. Your Honor, pursuant to the applicable statute, MCL 330.2020, Dr. Anaker has found that the defendant meets the statutory requirements for competency to stand trial and to go further for additional proceedings. As such, Your Honor, the people are requesting that the court adopt the recommendations in Dr. Anaker's report and enter an order for competency here today. Thank you.
Thank you. Mr. Cornish response, and Mr. Crino is asking that the court have this marked and admitted as Exhibit 1 for our purposes. Response to the prosecutor's request.
Thank you, Your Honor. Good morning again. That's a complete and accurate statement. We would stipulate to the entry of Exhibit 1, and we would ask the court to adopt the report as well, and just simply seek out a date for a probable cause conference and a preliminary exam in this matter.
All right, I'm going to have this marked as People's Exhibit 1. And I'll have that marked as People's Exhibit 1. And Mr. Cornish, you would stipulate to the admittance of People's Exhibit 1 and have it admitted for only for purposes of this hearing. Is that correct?
Yes, Your Honor.
All right. So with that understanding, I'm admitting People's Exhibit 1 for purposes of this hearing and stipulating with counsel to the admission of People's Exhibit 1 based on I've had the opportunity to read People's Exhibit 1. And along with counsel who stipulates Exhibit 1, I will adopt the recommendation and find the defendant competent to stand trial based on the report and then we will set it for a probable cause conference and a preliminary examination on this file. Do you want this? And I'd ask counsel, do you want this set aside for its own testimony, or do you want this just as part of a preliminary examination day? Mr. Crino, we have our choice on the matter a little bit.
Your Honor, my understanding is the defense is requesting a probable cause conference be set first and then a later preliminary examination date, and we have no objection to that.
All right. Is that a fair statement, Mr. Cornish?
Yes, Your Honor.
All right. So let's set a PCC date for probably
August 1st at 8:30.
So we'll set it for a probable cause conference on August 1st at 8:30.
That works for the defense.
All right. Does that work for you, Mr. Crino?
Your Honor, thank you. I want to check my schedule, but yes, it does work for the people. What time, please?
At 8:30, August 1st at 8:30.
Yep, that's perfect. Thank you, Your Honor.
All right. And then would you like a preliminary examination date on this date, or should we wait after the probable cause conference?
Your Honor, it's the people's preference that we have a probable cause conference on the 1st, as the court indicated, and then we set a preliminary examination date at that time. And I believe Mr. Cornish and I have discussed that prior to the hearing today, and we're both in agreement. That would be the best course.
All right, Mr. Cornish, that's a fair statement. We'll set the PCC for August 1st at 8:30, and then decide the preliminary examination date after we have the probable cause conference.
Yes, Your Honor. I know that both of us have very busy and complicated schedules, so I think that's the best
Right.
course of action.
All right. So we've set PCC date for August 1st at 8:30. I will sign the order later this morning to that effect. Anything else for the record in 24-01532, Mr. Crino?
Your Honor, thank you very much. Nothing for the people.
Mr. Cornish?
All right, thank you, Your Honor. Nothing from the defense today.
All right, that's all for the record in 24-01532. Mr. Labrie, your defense counsel, Mr. Cornish, will be in touch with you. Thank you for your appearance today.
Welcome very much. Thank you.
All right, thank you, Your Honor.
Thank you, Your Honor.
Thank you. Do an order. All right, Ms. Wilson, what's next?
First,
What's that?
Mr. Labrie might need to be told he can leave.
Mr. Labrie, you can let the jail know that you're done here, or they'll come get you.
That's fine. I don't mind waiting. It's nice
All right, thank
sitting
you.
here relaxing. So I hope everybody's having a good day. It is Friday, correct?
I believe that's
It-
Mr. Rush, but I'm not.
It is Friday, sir, and we're gonna go on to some other hearings, so thank you.
Yes, and that's a pretty United States flag there.
We're just gonna mute him.
That's probably wise.
Six, that's people of the state of Michigan versus Floyd Rush. Will the parties please introduce themselves for the record? Ms. Wilson,
Ms. Smith, Your Honor.
Ms. Smith,
Thank you so much. Melanie Smith on behalf of the people this morning.
and Ms. Wanji.
Good morning, Your Honor. Melanie Adiwanji for Mr. Rush.
And sir, you are Floyd Edward Rush, is that correct, sir?
Yes, sir.
All right, thank you. This is the time set for a preliminary examination today. Ms. Smith, how are we proceeding?
Thank you, Your Honor. I believe at this time, we're going to be asking for a good cause adjournment on this matter. This was a multi-jurisdictional investigation that involved detectives from the Eaton County Sheriff's Department. Although they did share their body worn cameras and other investigative material on evidence.com with us at the time of charging, because it's a different agency, apparently there's additional things that need to be done in order for the evidence to be shared with my office, and then thus so we can share it with Ms. Wanji's office. So in order to gather those recorded statements and the evidence of the actual crime allegations, we do need just maybe 2 or 3 weeks if the court would allow us to do so.
All right, thank you. Is that a fair statement, Ms. Wanji?
It is, Your Honor. Thank you.
Okay, and is this a request by both parties, a stipulation to adjourn for good cause?
Yes, Your Honor.
Yes, Your Honor.
And we're looking at a date of August 1st at 10 o'clock. How does that work with your prospective schedules?
Your Honor, I do have an exam with Judge Ward that morning that I do anticipate running and will probably take a bit of time. It's a delivery causing death. But if the court has all day available,
Maybe afternoon.
maybe the afternoon would be best.
How about August 2nd, anytime?
I'm a bit worried about that date, Your Honor. We have, here in this courtroom, I have two defendants that we adjourned yesterday. And then we also have a matter that's an arson case that I anticipate will run and take a bit of time. And then I have a very complex prelim in the afternoon, will just be canon.
August 22nd.
No, that's. 1, 2, 3. So it'd be an August 22nd date.
I am available anytime after 10 that day.
Ms. Wanji, August 22nd, does that work?
That's fine, Your Honor, thank
All
you.
right. So we'll set it for August 22nd at 1:30.
Perfect. Thank you so much for the flexibility of the court schedule.
So I'm going to adjourn for good cause. This means that Mr. Rush, you are not waiving any rights today. This is going to be adjourned for both parties by a request for both parties, really, but it's to get you full discovery so that you can be zealously advocated by Ms. Wanji in this case. Okay. All right. So we'll set it for August 22nd at 1:30. We'll adjourn for good cause. Anything else for the record in 24-01956? Ms. Smith.
Nothing from the people. Thank you.
Nothing further.
All right. You're all set, sir. Thank you for your appearance today. This is goes in the
Yes,
brief.
absolutely. Anything else? you need?
No, I think I should have been.
Report.
Thank you, Your Honor. Have a great weekend.
Thank you, Ms.
Thanks,
Smith.
Wendy.
You're welcome now. See ya.
And then this is Mr. Field.
I think we're ready on Coward.
All right, that's Alston Coward.
Yes.
Mr. Easterly, how are you?
I'm good, Your Honor. How about yourself?
I'm good, thank you. So we're on the record in docket 24-01720. That's people of the state of Michigan versus Alston Coward. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Easterly.
Good morning again, Your Honor. Robert Easton on behalf of the defendant, Mr. Austin Coward, who is present and standing to my right.
And sir, you are Alston Coward, is that correct?
Yes, sir.
Thank you. This is the time set for preliminary examination today. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. The complaining witness in this matter has not appeared. Our office has had contact with her. She was subpoenaed. It was left in her mailbox. The last time we attempted to contact her, her phone number was no longer working. I have no reason for her non-appearance today. I cannot proceed without her. I expect a motion from the defense.
All right, Mr. Easterly.
That's correct, Your Honor. The defense would move for a dismissal step.
Thank you. And my understanding is that the witness was subpoenaed and that you've had sporadic contact.
I
at
have had
best.
contact and she was willing to participate, but why she's not here today, I cannot explain.
All right. All right, I will gorely grant the motion made by the defense for dismissal. I should have a copy of that. Yeah, we just broadened your job description. So I'm in possession in docket 24-01720 of a nollie pros or order of acquittal at the motion of defense. This is done without prejudice, which means that the people could reissue if they choose to, but for our purposes today, the case is dismissed. All right, Mr. Coward?
Sir.
All right. Anything else for the record in docket 24-01720, Ms. Wilson?
Thank you, Your Honor. Just a reminder that all no contact orders and bond provisions take a minute to purge from lien. So just keep that in mind.
Yeah, I often forget. It takes about a day to get everything purged from the computer system. So just in order so that they'll still have you as no contact. I'd give it about a day, okay?
I might even give it even longer
but-
considering the computer issues we've got going on right now.
This is not a good day
It's
for
not.
technology for internationally. But I would give it at least a day to make sure that it's purged all the no contact order and all the orders of pretrial. All right, sir?
Sir.
All right. Thank you. Thank you, Ms. Wilson. Anything else for the record in docket 2401-720, Mr. Easterly?
Not for the defense.
All right, we're all set. Thank you for your appearance today.
Ms. Wilson, do you need anybody else brought up so that they could radio Megan?
Ms. Wanji, are you ready on Trevino? Are we adjourning that? Yeah, okay, I think we can bring up Trevino.
All right.
We don't have any work. No, you're. Sounds good.
This is like old school, isn't
Yes.
it? No working radios, no.
Well, the
Mr. Abbott, how
radios
are
aren't
you
working
today?
either.
Morning.
The radios
Well,
are working,
thank you.
but
How are
I
you?
don't have voice
Good.
to text.
Oh,
for
yeah.
Megan while she's trying to navigate jail.
No, I think I'm good. Thank you.
Sounds good. I will see you.
Appreciate it.
Hey, Ariel.
Oh, you just let Molly know I'm eating and I'll be out in a second.
Yeah.
I'll let her up. Fill her in.
Ms. Lawton, what case are you here on?
Kevin Thompson.
Oh,
One
I
of
think
them.
we're waiting for Mr. Johnson to appear by Zoom and his client as
All right,
well.
so Mr. Johnson is here
Oh, he is? Okay.
and
Is his client on Zoom?
I have a Bowers here.
That is one of the foster care workers on one of the cases.
I do not have anybody else. All right. So, Mr. Johnson, we're awaiting your client, Mr. Thompson, is that correct?
Yes, Your Honor. I've spoken to Mr. Thompson this morning. We first had contact probably about 8:30. His ride
All right.
was a little late. He is en route to the courthouse.
All right, and you're on both cases for Calvin Thompson today?
Yes, sir.
All right, the computer still has Robinson and Silverthorne as the attorneys on the case. So if you've already filed your appearance, that's why we're having a little bit of a disconnect because we have not received it yet. Although it could be still in the system.
Well, so if the court recalls last time, Mr. Johnson had submitted a substitution on the child abuse case to our office, but not to the court. And he had submitted a substitution on the home invasion case, but it did not have Mr. Silverthorne or his client's signatures. We have Mr. Silverthorne's signature now, but we need his client's.
All right, so when Mr. Thompson comes in, he can, and we don't have any of that. I do have on the child abuse, I have and I do remember signing that, at least one of those documents. Or there was a substitution of counsel maybe that I signed?
So if I recall correctly.
Here it is.
Is it signed?
It is not signed by myself. That's the one that Mr. Thompson has to sign.
Okay, yeah, I think we're still waiting for the substitution on the other file.
All right.
I believe it needs to be submitted through the clerk's office, if I'm not mistaken.
All right.
And Wendy is nodding her head, so I believe that's correct.
All right. So, so let's have Mr. Thompson sign the document when he gets here, when the case is called, and then we will forward it. Okay. All right.
Can I just ask Mr. Johnson? Mr. Johnson, is this going to be a plea today, or do we need to have any other further discussions on this?
So it's not going to be a plea today. We just want to put the offer on the record when Mr. Thompson gets there, and I have to ask for an examination date.
Okay.
All right.
So my detective on the home invasion is here on another case. We had brought in one witness on each file just to make sure that we can show that we've been moving forward. Am I okay to release that officer when she's done with her other file?
So Mr. Johnson, is the plan right now to ask for, because this is date set for prelim and we have one witness on each
And I
case.
believe this is Mr. Thompson.
All right. Oh, and Mr. Thompson is here. Well, let's go ahead and put it on the record.
Yeah, if we want to do Mr. Trevino first, since he was just
All
brought
right.
up from the jail.
So let's do Mr. Trevino and then we'll do Mr. Thompson, who is present.
Yes, sir, Your Honor.
All right. And so we're on the record in docket 25-23-00538. That is people of the state of Michigan versus Ronnie Trevino. Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson, for the people.
Ms. Wanji.
For Mr. Trevino.
And sir, you are Ronnie Ricardo Trevino, is that correct? Thank you. This is the time set for a preliminary examination today. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I do have my officer here today and the people were ready to proceed. It's my understanding the defense is hoping to look at the body cam footage from this incident. I have requested that, but I requested it yesterday. It usually takes a minute, but now everything's down, so it's gonna take even longer, I'm guessing. So I believe we're gonna be requesting a good cause adjournment so the defense can get that information.
And is that a fair statement, Ms. Wanji?
It is, Your Honor. Thank you.
All right, I am going to grant the request to both parties for an adjournment in this matter. For continued discovery purpose. This would be for good cause. We also are having some technological issues, but this is a good cause adjournment. So Mr. Trevino, you won't be waiving any rights today that you might have. And this adjournment is so that Ms. Wanji has all the information and material provided to her by the prosecutor's office so that she can advocate for your defense. Okay, sir? All right. So we'll reset it for
August 1st at 9:30.
first at 9:30. So this is set for August 1st at 9:30 for the reset preliminary examination. And my understanding is the discovery is in process. Anything else for the record in 23-00538? Ms. Wilson.
Not for the people, thank you.
Ms. Wanji.
You know, I would like to address bond, and I know things have not changed, but my client's circumstances have not changed. Also, I think the court set up a 2010%, and it is my understanding that my client is really unable to post that amount of bond. And I think he's eligible for a contingency debtor, so we will ask the court to set a PR bond and allow him to get a debtor.
All right, request for modify or reduce bond, Ms. Wilson.
Thank you, Your Honor. If the court recalls at the last hearing, the court didn't state that bond based on the circumstances the court knew. If nothing's really changed, and then I don't think that a bond modification at this point is appropriate. 2010%, I mean, there's a criminal history here. There's possession of prohibited items. I think that's pretty appropriate.
Thank you. Based on the nature of the offense, which is prohibited, a felon in possession was typically known as felon in possession. It's the fact that a gun was found, or the allegation is the gun was found.
Just ammo, Your Honor.
Okay, what's that?
Just ammo.
Just ammo?
Yep.
All right. I'm going to deny the modification of bond at this time, and we'll continue on the 2010% that was previously set. And we'll set this for August 1st at 9:30. Thank you. You're all set, Mr. Trevino. Thank you for your appearance today.
Judge, would you like me to grab anybody else?
What we're gonna do, we're going to call the case of Mr. Thompson right now.
And then I would like to do Mr. Chapman after that. I do have officers here that have been waiting.
All right. Did you want anybody else brought up now, or did
Not
you?
right now.
Okay. So, all right.
Oh, yeah. Wendy, have you heard of Thompson is here?
Dominic Thompson?
Dominic, yeah.
He's in custody.
The writ has arrived.
Yeah.
I will.
Yeah.
They don't have a computer to email.
Oh, okay. That's annoying.
All right, so let's call to the record Calvin Thompson. And this is gonna be reset. Yes. So let's call first 24-00886. That is People of the State of Michigan versus Calvin Thompson. And So do we need anything on that file? Because I have I have the.
I believe you have the substitution on 1644, and we're still awaiting the substitution on 886.
All right,
I don't have a substitution on
Okay.
886. I don't have an appearance. I don't have anything.
all right. So I'll take appearances for the record, and then Mr. Johnson, we don't have any appearance or substitution on this file 2400886. So you might want to check into that to make sure that the court has any appearance or for purposes of representation. But appearances for the record on 2400886, Ms. Wilson.
Miss Lawton.
Ms. Lawton, that's
That's okay. Good morning, Your Honor. Jennifer Lawton, on behalf of the people on file 2488.
and Mr. Johnson.
Good morning, Mayor. Please, this honorable court, Kareem Johnson, on behalf of Mr. Thompson, on file 24886 FY.
And sir, you are Calvin Thompson, is that correct?
Yes, Your Honor.
Right, thank you. This time set for preliminary examination on this file. I'll tell you the court's understanding, and then I'll let each side make a record. It's my understanding that the attorney on the case for Mr. Thompson is currently, we know this from yesterday, is currently under a quarantine order for COVID, for being diagnosed with COVID. And therefore, that's why he's joining us by Zoom. With that understanding, this is time set for preliminary examination. Seems like that would be a good cause in order to adjourn this adversarial setting. So Mr. Johnson can have Mr. Thompson at his side in person and can cross-examine any witnesses that may be brought against him by the people. So I would entertain a good cause adjournment at this matter at this time. Ms. Lawton, you may proceed.
I have no objection to that request, Your Honor. That's certainly understandable.
And Mr. Johnson.
Yes, Your Honor, that's correct. Thank you. As the court indicated yesterday, I was given the date of August 2nd for an examination date. If that date is good enough for the people, I'd ask the court to adjourn this matter to August 2nd as well.
So let's take a look at that August 2nd. How does August 1st work for your schedule, Mr. Johnson? Because August 2nd is getting full.
I'll be in Oscoda County August 1st, Your Honor. So,
oh, that's right.
Yep.
And then this is two files we're going to set aside for its own time. Maybe we go a week later, or the 22nd. So in order to keep both files together, and I don't know that they need to be kept together, but that August 2nd date is getting packed. The next available date would be August 22nd at 8:30.
I have a trial scheduled that day, Your Honor.
Then let's go further. Let's go to.
Can you do the 23rd?
Is that trial going to the 23rd? Mr. Johnson, you indicated that you have a trial scheduled for August 22nd.
Yep.
We might be able to schedule it on August 23rd, but if the trial goes into the 23rd, we'll look at a different date.
Your Honor, I am not available on the 23rd.
Okay, well, that answers that question. So let's go to the 29th.
That's a good day for me, Your Honor.
All right, so let's do August 29th at, and Ms. Lawton, does that fit with your schedule?
It does, thank you.
Okay, August 29th at 1:30? At 1:30. So we will adjourn this prelim, and it's a good cause adjournment based on conflict with sickness or quarantine status. And we'll reset for August 29th at 1:30. And then Mr. Johnson, you can double check on the appearance for the court. It doesn't mean you didn't do it. We just don't have it yet. So you might want to run up on or check on that. But we'll reset for August 29th at 1:30 on 2400886. Anything else for the record, Ms. Lawton?
Your Honor, if I could just put the plea offer on the record.
Okay.
And this is actually a plea offer regarding both files. as well as a file that Mr. Thompson has pending in the 55th District Court. He is currently charged in the 55th District Court with a felony possession of a controlled substance case. File 24886 is a child abuse case, and 24164 is a home invasion case. There has been a global offer made regarding those files. The offer would be on the child abuse case to plead to an amended count of child abuse 4th degree. That's a 1-year misdemeanor. In exchange for felonies, and that file would be dismissed. I did then give Mr. Thompson an option that he could either plead to a misdemeanor use of a controlled substance on the 55th file, or to a misdemeanor domestic violence charge on the home invasion file, and the remaining felonies in both of those files would also be dismissed. It's my understanding that Mr. Thompson wants to reject that file. I do want to make it very clear that that is a district court only offer. That offer will not be extended again if witnesses are needed to appear. I have very fragile child witnesses. And so if those children are forced to come in to court, that offer will not be available again.
All right, thank you. And then Mr. Thompson, you heard the offer, and Mr. Johnson, you'll get the opportunity to discuss the offer more with your client. But at this time, we've set this for August 29th at 1:30. Is that a fair statement, Mr. Johnson?
Yes, Your Honor.
All right. So with the offer placed on the record, we'll see everybody on August 29th at 1:30 on 2400-886. And then we'll call to the record the second file of 2401-644. And Ms. Slaviak, I'm going to have Mr. Thompson sign the substitution of attorney. There's a substitution of counsel that he can sign. You may need a pen. So on the record in 2401-644. And appearances for the record, Ms. Wilson.
Abigail Wilson for the people.
Mr. Johnson.
Good morning, man. Please, the Honorable Court, Kareem Johnson, on behalf of Mr. Thompson.
All right, and then Mr. Thompson, you are Calvin Lewis Thompson, is that correct?
Yes, Your Honor.
All right, and it was just missing your signature as for substitution of counsel so that Mr. Johnson can appear at your request. I want to make sure you're signing in the right place, or that you see. Yeah, that looks right. All right, if you provide that to Ms. Slaviak, I'll put it in the court file, and we will make sure that this gets to the criminal department. Substitution of attorney was signed by Mr. Thompson. And Ms. Wilson, how are we proceeding today?
Thank you, Your Honor. This is similar to the case that the court just called. As the court's aware, Mr. Johnson has COVID today and is not able to appear. So the parties will be requesting a good cause adjournment. His other file was set for 8/29 at 1:30. If I'm not available that day, I'm sure somebody else will be available that day. I know Mr. Johnson's available, so I'll be requesting that date. All right, and that's a fair statement, Mr. Johnson. We'll be resetting this file for August 29th at 1:30. It'll be adjourned for good cause based on the quarantine. Is that a fair statement?
Yes, Your Honor. And on this file, we would actually be requesting that the files be merged. One of the defenses that we will be asserting in the home invasion case is that my client lived there, and there's ample evidence from CPS and police in the alleged child abuse case that my client lived there. There was direct statements from CPS and the complainant witness that he lived there. So if the court, I think it's best for judicial economy, we will be subpoenaing some of those witnesses from the child abuse accusations to testify in the home invasion case. And since they're already, I assume, are going to be there to testify in one case, I'd ask the court to just take proofs as to both cases together.
All right. Ms. Wilson responds.
I don't know that it would be necessarily appropriate to take the proofs at the same time since the cases aren't formally joined at this time. I have no problem with us having people hang around on that date to take proofs on each one, but I think that they need to be done separately for clarification.
I'm not going to merge the two cases. They're not similar counts. They completely fail any Blockberger test, which I know the court would look at, or at least would confirm, or would be the goal as to similar counts, would be the Michigan's version of the Blockberger test, and the elements of these two crimes, child abuse and the home invasion. But for some venue proceeding in this, the elements are completely different. So I'm not going to merge the two, but the witnesses will be here and we're set for the same day at this time. So if they all choose to be here, you know where they're going to be.
I don't know if the CPS workers were planned to be called by the people in the child abuse case. I'll leave that to Ms. Lawton's communication with Mr. Johnson. It's my understanding that the primary witness was going to be at least one of the children.
All right. All right. So I'm going to adjourn for good cause on August 29th at 1:30, but I will deny any merger at this time. Motion to merge the case.
Yes, sir.
But it is being reset with the other companion, with the other file, which is 2400886. And this will be on the same date of August 29th at 1:30. It's adjourned for good cause, Mr. Thompson, so you won't be waiving any rights. And we'll reset it for that same date at the 1:30 date, or at 1:30 time.
Yes, sir.
Anything else for the record in 2401644? Ms. Wilson.
Yes, Your Honor, I know the offer was placed on the previous file, but I would like to place it on the record in this file as well.
All right, you may proceed.
Thank you, Your Honor. The offer in this matter is for the defendant to plead to a child abuse fourth on 2400886. It's a 1-year misdemeanor. The additional offer is that the defendant can choose to either plea on his 55th file to a use of a controlled substance, that's another 1 year, or he can plead to a domestic violence on the file before this court, that is 2401644. That's the file we're on the record for here today. That is a 93-day misdemeanor. Basically, it would need to be a child abuse fourth and another misdemeanor on one of the other two files. That offer, similar to the offer on the child abuse case, is only open in district court. It will not be re-offered in circuit.
All right, Mr. Thompson, you understand the nature of the offers been placed on the record. You'll have till the August 29th at 1:30 date to go over that with with Mr. Johnson, your attorney. Okay, sir?
Yes, sir.
All right. Anything now that the offer's been placed on the record? Anything else for the record in 2401644, Mr. Johnson?
No, Your Honor.
All right. You're all set, Mr. Thompson. We'll see you on that August 29th date at 1:30.
Okay, got it. Have a good day.
You're all set, Mr. Johnson. Thank you for your appearance.
Thank you, Your Honor.
And Mr. Lawton, Ms. Lawton, I think you're all set on that case.
I am, thank you.
So Mr. Thompson, is that Mr. Thompson? Dominic Thompson?
Yes, and I believe he's here.
He's here?
We
All
just
right.
talked to him.
So he's here.
Yep, and I believe I'm ready on Chapman. It's my understanding that's gonna run. Yes. I thought it was the two seasons. Right, he'd have to plead to it and start, he'd waive up with what he has and then plead to this two seasons. Because he's got the discharge and everything else going on.
Yeah, he's got some higher stuff going on.
Yes. Okay. Yes. Yeah,
All right, I
that's
will-
my recollection of the
That is
offer.
mine as well. I
Yeah.
just wanted to make sure we were on the same page. All right, I will go talk to him. Thanks.
All right, and then,
No, it's not the-
so
Shondell Chapman. I believe
Shondell
we're right on.
Chapman, all right, let's go ahead and we'll call Shondell Chapman.
If you don't mind popping that in. She's doing one.
All right, so we're on the record and actually before, so this is Mr. Chapman and Ms. Schroeder's talking to Mr. Thompson,
Mhm.
and then I have a Mr. Peterson.
Yes, he is also Mr. Evatt's client. It's my understanding he's downstairs as well,
All right.
or he should be.
All right, so we're on the record in docket 24-01-991. That's people of the state of Michigan versus Shondell Chapman. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Abbott.
Good morning, Your Honor. Attorney John Abbott representing Mr. Chapman. He's standing to my right.
And sir, you are Shondell Chapman, is that correct?
Yes, sir.
All right. This is the time set for a preliminary examination today. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. It's my understanding that the defendant wishes to reject the offer that's made and proceed to his preliminary exam, as is his right. For the record, I would just like to place the offer on the record. The offer is that the defendant today plead to an attempted resisting and obstructing that would make it a 1-year misdemeanor and/or I want to say $1,000. That offer is only available today. If this case runs and it is bound over, it will not be re-offered in circuit.
And that's your understanding, Mr. Abbott?
It is, Your Honor. I've discussed that with Mr. Chapman, and he says, no, thank you.
So we'll run the preliminary examination today. Ms. Wilson, anything to come to the court's attention before we start the testimony on 24-01-991?
I just a general sequestration. Both of my witnesses are officers. I believe they're both in the jury room.
All right. And so what I'll do is I'll invoke the general sequestration, but at least listen to I'll wait for counsel to tell me if there's anybody in the courtroom which should not be in the courtroom and hear another witness's testimony. I'll leave it to the attorneys who know their case better than I do. There's nobody in the courtroom right now, so I think we're good. You have a similar request, Mr. Abbott. And is that correct?
That's correct, Your Honor. I have no witnesses today.
All right. So Ms. Wilson, you may call your first witness.
Thank you, Your Honor. The people would call Officer Nicholas Shading.
All right, Officer Shading, I'm going to have you come up here. And please stand right in front of me, spell and state your first name and last name for the record.
It's going to be Nicholas Shading, Nicholas, last name of Shading, Shaeeding.
Please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right, go and have a seat, Officer Shading, and please project to the back of the room. The microphone is for the court recorder. And Miss Wilson, when you're ready.
Thank you, Your Honor. Officer Shading, where do you work?
Lansing Police Department.
And what is your job title?
I'm a police officer.
What are your general duties?
Patrolling the streets of Lansing, protecting citizens, and serving community.
All right. And were you working as a Lansing police officer on July 4th of 2024?
I was.
And do you recall how you were dressed on that date?
In a full police patrol uniform.
Okay, and does that have any markings on it designating you as police?
Yes.
Can you describe those a little bit?
It does have my badge and it also has Lansing police logos on the sides of my arms.
Okay, and were you alone in your duties that date?
What do you mean?
Were you patrolling by yourself? Did you have
I
a
was,
partner?
yes.
Okay, you
No.
were patrolling by yourself?
Yes.
Okay, and on that date, do you recall that July 4th date, do you recall responding to the area of 2211 Risdale Avenue?
Yes,
And to the best of your knowledge, is that in the city of Lansing,
it is.
Ingham County,
Yes,
state of Michigan?
correct.
Okay, and generally speaking, what was the reason for that call?
We were, from what I can remember, we responded there for a possible fight. We've had to do with somebody running someone over with another vehicle. So obviously I responded to that.
Okay, and so you said you responded to that.
I did, yes.
Did you respond to that area?
I did.
Okay, and is that area still within the city of Lansing?
It is.
Ingham County,
Yes.
state of Michigan?
Yes.
Okay, and did you make contact with anybody on that date?
I did.
Did you at some point get that individual's name?
I did not retrieve the individual's name until we made contact with him and actually asked him multiple times, which he refused to give us his ID.
Okay, and when you saw him, was there a reason why you stopped him?
So we stopped him because the victim, who was apparently involved in this assault that we were investigating, pointed him out. When I first arrived on scene, I was still in my patrol car. Sergeant Dykins pointed out the individual who was walking across the field at the time behind some apartments. He said that was the person who was involved, the other person. So I got up to him, myself and Sergeant Dykins, we approached him because he was possibly involved in this assault.
Okay, and when you approached him, what did you do?
We first approached him. I stood by while Sergeant Dykins was asking for his identification. Of course, he was not giving it to us.
Okay, and so once he's not giving you his identification, what happened?
After he continued not give us his identification, at one point he gave us a name. I don't remember exactly what the name was, but then I remember Sergeant Dykins called over to another officer who was with the victim.
Your Honor, hearsay.
Response.
Yeah, I believe it's going to go to effect on the listener as to what he did next after receiving this name.
So at this point in time, I'm not using it substantively, just being used for effect on the listener as to what each officer did in response to the request, but it's not going towards any substantive elements of the crime.
Thank you, Your Honor. Officer Shading, I believe you said that Officer Dykins had run the name that he had provided or something. Can you continue with that?
So once we got the name, we both, obviously at that point, we haven't confirmed if the name that he gave us was actually factual or not, if it was his legal name. So we contacted Officer Noah Mwangi over the radio, and she advised that we do have enough to detain Mr. Chapman on what we have regarding this assault.
Okay.
Figure out exactly what's going on.
And so did you then initiate detaining him?
Yes.
And what happened when that happened?
So once we detained him, he continued to resist us, pulling away. I tried to put him in handcuffs, and it probably took me a good 30 seconds, 40 seconds for me to actually put handcuffs on because he continued to pull away from me.
And is that 30 or 40 seconds, is that unusually long for detaining someone?
Very long.
Okay, and when you said that he was resisting and pulling away, can you kind of describe what that looked like?
So I was on his right side, Sergeant Dykins was on his left side, and of course, when I was the one initially trying to put the handcuffs on, and he continued to jerk his shoulder over, just trying to push away from me, just the opposite of where I was. He continued to try to pull his hand away from me as I was trying to get the cuffs on.
Okay, and that individual that you arrested, on that date, did you get a good look at him?
Yes.
Would you recognize him if you saw him here today?
Yes.
Do you see him here in the courtroom?
I do.
Can you point him out and describe something he's wearing?
Right there with the Jersey Mike's Sure.
Thank you. Your Honor, I'd request that the record reflect identification.
No objection, Your Honor.
No objection. Without objection, the witness has identified the defendant for purposes of prelim.
Thank you, Your Honor. I have nothing further at this time.
Cross-examination, Mr. Abbott.
Thank you. Good morning.
Morning.
So while you were responding, there were several other cars with LPD officers in the same spot at the same time?
Correct.
And one of the officers there was Officer Mwangi?
Correct. She was with the victim.
She was interviewing a person in a white car,
Believe so, yes.
female?
Yes.
And were you aware that the female did not report any assault?
After the fact, yes.
And did you were aware that she did not report any property damage?
I was aware of that after the fact, yes.
And in fact, there was nobody on scene that was interviewed by any officers that identified themselves as being a victim of an assault. There was no one there that had been assaulted.
At the time?
Yeah. The time the police were there. There was no one there that said they had been assaulted.
I was not informed that at the time.
Okay. And as far as being hit by a vehicle, turns out it may have been somebody hit a vehicle with their hand. Is that correct?
I'll be honest, I do not exactly remember.
Okay, so when you were arresting Mr. Chapman, he was being arrested for what?
At the time, for resisting obstructing.
So you were arresting him for resisting arrest?
Correct.
Thank you, nothing further.
Ms. Wilson,
Yes, Your Honor. Thank you.
redirect.
Yes, Officer Shading, so when you approached Mr. Chapman or the individual that you detained, at that time, did you have any information other than what you had been advised about the call?
So if I can remember correctly, they
Would
did
reading
say,
your report help you remember?
yes. if you could.
Okay, Your Honor, permission to approach.
You may approach to refresh.
Officer Shading, I'm going to hand you your report here. If you can go ahead and give it a look over, read it to yourself silently. Once you're done, you can flip it over and then I can ask you some more questions.
And let the record reflect that Mr. Abbott has had the opportunity
Yes, he has.
to see the what you're refreshing the memory with.
All right, thank you, Officer Shading. After reading that report, is your memory refreshed?
Yes.
Okay, so now when you approached Mr. Chapman, did you have any information other than what you had been advised by dispatch?
So when I first got there, within the area, Sergeant Dykins advised over the radio that the subject, he was wearing a white shirt and a black backpack.
Okay,
So-
and the individual that you approached, did that individual match that description?
Yes,
Okay, and so at that point, you stopped him, is that correct?
I did.
And were you hoping to gather more information about your investigation?
Yes.
And at that point, was he cooperative with your investigation? Did he provide any information you knew to be false?
At the time, I was unsure.
Okay, but he wasn't cooperative, to fair to say?
Very uncooperative,
Okay.
yes.
I have nothing further, Your Honor.
Mr. Abbott, any questions based on the redirect?
Your Honor, just if we're gonna do recross, I would request the right to redirect again.
That's fair. This is but there was a clarification on the refreshing of memory. Mr. Abbott, do you have any questions on that?
I don't think so, Your Honor.
All right.
Thank you.
All right, thank you. May this witness be excused from the people.
You may, Your Honor, thank you.
May this witness be excused from the defense.
Yes.
All right. Sir, you're excused. Thank you for your appearance today.
Thank you.
Ms. Wilson, further proofs today.
Yes, Your Honor, thank you. The people would call Sergeant Darren Dykins.
Officer Dykens, you can come up here. Stand right in front of me and right here and state your first name and your last name and spell them both for the record.
Darren Dykens, Darren Dykens.
Please raise your right hand. Do you solemnly swear or affirm, tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
All right, have a seat. The microphone is for recording purposes, so please project to the back of the room as best you can. And Miss Wilson, when you're ready.
Thank you, Your Honor. Is it Sergeant Dickens?
Yes.
Sergeant, where do you work?
City of Lansing Police Department.
And you're a sergeant, is that correct?
Yes.
And what are your general duties as a sergeant?
Supervise the patrol officers that are assigned each shift, reviewing reports, responding to 911 calls, and supervising actions.
Okay. And how long have you been a police officer?
Coming up on approximately 11 years.
Okay. Has the entirety of that been with Lansing Police?
For the approximate 11 years, yes.
Okay. Now, were you working as a police officer with Lansing Police on July 4th of 2024?
Yes.
And how were you dressed on that date?
I was in a fully marked police uniform with Lansing Police patches, a Lansing Police badge.
All right. And on that date, do you recall responding to a dispatch at the area of 2211 Risdale?
Yes.
To the best of your knowledge, is that in the city of Lansing?
Yes.
Ingham County?
Yes.
State of Michigan?
Yes.
And do you recall what that dispatch was for?
I believe it was for a fight that was occurring, possible damage to property. I didn't have access to my report, so I'm just going off the recollection of
Okay, so that's what you recall it being?
something along those lines.
Okay, so basically you were dispatched because there was some kind of fight or something going on. Is that what I'm hearing?
Yes.
She's leading in there.
I'll sustain it. I'll sustain the objection. So you can rephrase, Ms. Wilson.
I'll just move on. So what was your role in that call?
Initially, I was the backup officer.
Okay, and so did you end up actually going to that address?
Yes.
Or the area of that?
Yes.
And the area that you responded to the best of your knowledge, is that still in the city of Lansing?
Yes.
Ingham County?
Yes.
State of Michigan?
Yes.
Okay. Now, at some point, was an individual arrested that night?
Yes.
And what kind of prompted meeting with that individual?
To investigate the altercation, then a possible damage to property incident.
Okay, and were you provided with any information about who might the accused be in this situation?
Yes.
And what was that?
The 911 caller had pointed out the subject that was involved in the possible altercation, which I could see from where I was at with the 911 caller. There was a direct line of sight.
Okay, so at that point, did you then approach that individual?
Yes.
Okay, what happened when you approached them?
When I approached the individual, I had activated my emergency red and blue patrol vehicle lights to, advise the individual who's being quote unquote detained.
So at this point, you're in a car, is that correct?
I drove over to him.
You drove over,
correct.
and what kind of car was that?
A fully marked Lansing Police patrol vehicle with Lansing Police decals on the side, equipped with emergency equipment, sirens, or I guess audible signals, and emergency red and blue lights.
Okay, so once you drove over to that person and turned your lights on, what happened?
I then stepped out of my motor vehicle. I approached the individual on foot. I had observed the individual to be, covered completely in blood, but there was some blood on his person. Through my training experience, it appeared that the individual had just been involved in some type of altercation, and then furthermore, he was also appeared to be under the influence of intoxicating beverages, as I could smell light odor, and the individual was, his speech was just kind of slightly disorganized.
Okay, and did you eventually actually make contact with him?
Yes.
Sorry, go ahead.
I spoke with the individual. Yes.
Okay, and at some point were you able to determine that person's identity?
Yes.
How?
Eventually, we were able to get a state ID from his person, which I later I ran that in a law enforcement database.
Okay, and the information that came up in that database, did that match the individual that you had in custody?
Yes.
Do you recall that person's name?
Shondell Chapman.
Okay, and during this altercation, did you get a good look at this individual?
Yes.
And do you see him here in the courtroom?
Yes.
Can you point him out and describe something he's wearing?
He's to my left, wearing a baby blue shirt.
Thank you. Your Honor, I just request that the record reflect identification.
No objection.
Without objection, the witness has identified the defendant for purposes of preliminary examination. You may proceed.
Thank you, Your Honor. So when you approached him, was he cooperative?
Through my training experience and interactions with multiple individuals throughout my approximate 11-year career, I would say he was not fully cooperative because he would not provide state identification. He, at one point, if I recall correctly, like flexed his arms, which is, through my training experience, is a pre-indicator of a possible assault that may take place. I told the individual to stop that, and then there was other times I recall that he would back away from us, which is a pre-indicator of a possible individual that may attempt flight from law enforcement officers. I believe he had said that some family member had lived nearby in the area. He had also attempted to step forward towards where he had advised the individual lived, which is also a pre-indicator for my training experience that the individual may attempt to flee law enforcement officers to get to a nearby residence to escape us.
And what was your concern with him potentially fleeing?
The fact that the individual had not been ID'd at the time, and that we had not, it's more of just not having him ID'd in case, you know, the victim wants to go forward with prosecution.
Okay, so at that point, then, did you believe that this was the individual you were looking for?
I'm sorry, I just called.
That's okay. So at this point, then, in your investigation, did you believe that that was the individual you were looking for?
Yes, because the victim had, or I guess the 911 caller had specifically pointed this individual out.
Okay. And so at some point, was he detained?
He was.
And can you tell me a little bit how that went?
Yeah, so I guess I advised the individual, you know, he's being detained. Officer Shading and I approached him on foot. He was, you know, resistant and placing his hands behind his back. Once we finally were able to put him in handcuffs, we began escorting him over to the patrol vehicle. He had also stopped our movement and his movement, and we had to use strength and leverage in order to escort him over to the patrol vehicle. Once to the patrol vehicle, when we were conducting our search, he kept turning his body into officers, and I believe was advised to stop. Then when the officers went to put him into the vehicle, he had also gave resistance then.
Okay. I have nothing further this time, Your Honor.
Cross-examination, Mr. Abbott.
Thank you. Good morning.
Good morning, sir.
So in the process of making this arrest, there were you and several other cars full of LPD people on the scene? 4 or 5 cars?
During the detainment, I believe it was just Officer Shading and I initially.
Right, okay. And you did speak with Officer Mwangi? Or
yes.
She was the person interviewing the caller, correct?
Yes, because I was there initially.
And they were either standing next to, or the caller might have been sitting in a white sedan that was parked there.
I believe it's the white sedan, yeah.
Okay, and that's where she said, and that's him pointing, and she pointed down the street, and that's where you guys went?
She pointed at the
thing.
Yeah, the defendant, and then that's where we had went, yeah.
Okay. And then you spoke with Mwangi after that as well?
There was like a radio transmission that occurred.
But based on what you heard and what you, based on the whole investigation, there was actually no one present who claimed to have been assaulted, right?
At that time.
And there was no one identified that got found later who complained of an assault either?
No.
Okay, and there was no one that complained of any property damage?
Not confirmed property damage, but when I was initially on scene, I recall her saying that her vehicle was struck.
Right. She said he hit her car.
Yeah.
I guess struck, hit, same thing.
Yeah. Yep.
But she didn't complain that he damaged her car. She never said that her car sustained any damage.
Specifically said that damage was sustained. I just recall that it was like struck or hit or something like that, which prompted the investigation of possible malicious destruction of property.
But the caller herself never reported any destruction of property to you.
She said that her vehicle was struck.
Okay, but
and
I just struck this table. I didn't cause any damage. So she never reported that her car was damaged.
Your Honor, I think this is asked and answered at this point. He is advised that he was told that the car was struck. If that's all he was told, that's all he was told.
I'll allow him that to respond to the question, and if that's the answer he's giving, he can clarify it. So is that Mr. Abbott, you can ask the question again.
Sure. I can remember. So she actually never reported any property damage to the car to anybody.
Can you define like damage?
Well, I'll leave that to you. Were you aware of any damage? Did you see any damage that was alleged to have been caused by his striking?
No.
Okay, thank you. Nothing further.
Any redirect, Ms. Wilson?
Briefly, Your Honor. So Sergeant Dykins, I just want to clarify. So when you arrived on scene, what was the information that you had?
There was an altercation that took place and that vehicle was struck.
Okay, and when you got there, how long were you there before the caller pointed out the individual walking down the street?
Within, I think, a couple minutes.
Okay, so how much information did you get from that caller before they were pointing down the street?
Minimal.
Minimal? Okay, nothing further, Your Honor.
May this witness be excused from the people?
You may, Your Honor.
From
Yes,
defense.
thank you.
Sir, thank you for your appearance. You're excused.
Thank you, sir. Have a good day.
You too. Ms. Wilson, any further proofs?
No, Your Honor, the people rest.
All right, Mr. Abbott, any proofs today from the defense?
No, thank you.
All right, motion for bind over, Ms. Wilson.
Yes, Your Honor, if I could just have a brief moment. All right, at this point, Your Honor, just for clarification purposes, the defense currently charged with one count of resisting and obstructing. Based on the testimony we hear today, during my bind over argument, I'm going to be requesting an additional count. We have a testimony here today that officers responded because they heard a complaint of a fight and a possible destruction of property. They arrive, Officer Dykins testified that he's arrived and the complainant had pointed out the individual walking down the street as the person the call was in reference to. He then went to that person with Officer Shading, and when they got there, I believe Officer Shading testified that the individual was kind of bloodied. I believe Officer Dykins testified that he was kind of intoxicated and that there were some concerns about some ongoing criminal activity. They detained him after he was not initially cooperative with their questioning. Officer Dykens, who's been an officer for upwards of 11 years and is currently a sergeant, testified that there were some indicators by the individual that was being detained that he may flee, and there was concerns because they were investigating a possible assault offense, so they detained him at that point. While they were detaining him, he pulled away, resisted, refused to get in handcuffs. Officer Shading testified at that point that it took an abnormally long amount of time for them to get him into cuffs. Additionally, Officer Dykens testified that as they were walking this individual back to the patrol car, he was uncooperative, refusing to go to the patrol car. So based on the statements here today, additionally, both officers pointed out Mr. Chapman is the individual they arrested. Officer Dykens knew that through a state ID that was recovered that Mr. Chapman was Shondell Chapman, and that was the individual that he had arrested. So the element of ID has been met. Additionally, they responded to the area of 2211 Risdale Avenue. They said that the area that they were in was in the city of Lansing, Ingham County, state of Michigan. So venue has been met as well. And the reason why I'm requesting the second count is because the first count is solely to Officer Nicholas Shading. Based on Officer Dykens' testimony here today, he was also present, he was also giving lawful commands, and the defendant also resisted those lawful commands. So for those reasons, I'll be requesting a second count of resisting and obstructing as to Sergeant Dykens, and the habitual offender notice to follow.
Thank you. Response, Mr. Abbott.
Thank you. As Officer Shading testified, the defendant was arrested for resisting and obstructing. In order to get arrested, there has to be an underlying crime that you're being arrested for. We've also heard testimony that there might have been a fight. There was physical evidence that there had been a fight, but there was no assault claimed by anybody. The caller never claimed she was assaulted. She never claimed she saw an assault. There might have been a fight, but there's no testimony about who started it or what it was over or who was involved. So there's really no evidence of an assault that he could have been arrested for. And there was certainly nobody here today or identified at the scene on that day that claimed that they had been assaulted. So there was no assaulted crime being investigated. In fact, the caller stated, I don't know what she stated about the assault. She stated that he hit her car, but she never stated that she felt that she was in fear of anything. She was irritated. The guy who apparently had been drinking that day. But there was no report by the caller, and the caller was still on the scene when the police got there. When they talked to her there, she never reported a crime. She had only called the police because it was a situation she thought could use police presence. It wasn't because she'd seen a crime. She wasn't reporting the crime, and nobody that testified today saw that he committed a crime or that they had any reason to suspect that he had committed a crime. The point being, Your Honor, that in order to make an arrest, there has to be a basis for that arrest. It has to be a lawful arrest, and merely, matching the description of the guy that might have been in a fight isn't a reason to arrest him. So I'd ask the court not to bind him over, since there's really no basis for the arrest in the first place.
Thank you. Ms. Wilson, response.
Thank you, Your Honor. I have a couple things I want to get into here. There is case law previously that the issue of a lawful arrest is a matter for a finder of fact, a jury. There is some new case law out there that it is also an issue for the determiner of probable cause to evaluate. I recognize that we're at a probable cause standard here. It's pretty low. That being said, there was a lawful reason for this individual to be detained. First of all, an officer claiming or calling it an arrest because of a resisting and obstructing is really irrelevant. They can call it what they want. The issue is whether the facts are reasonable or meet the legal requirements for the arrest. Here we have officers arriving at the scene. Not only did the defendant match the description they were giving, but the complainant actually pointed down the street and said, "That's him." Officers then went there. At that point, they had zero information other than, or the officers going to do the arrest had zero information that he was, or that there was whatever statements being made to Officer, I think it's Mwangi. I can't pronounce her name often. So they're responding. Their information is that there is possibly an assault, possibly a destruction of property. They have an individual that's been identified as the person who was involved in this call. This person is bloody, this person is intoxicated, this person is uncooperative. That's a pretty reasonable suspicion that they've got a crime afoot. They then have the ability to stop that individual for an investigation. If he's not cooperative in an interest of avoiding his flight to avoid investigation, and also for public safety, officers have the ability to then detain him. That's what happened here. Resisting and obstructing under the model criminal jury instructions is not resisting and obstructing an arrest. It is resisting and obstructing a lawful command. Officers here were operating within their lawful duties, giving lawful commands as they were investigating a crime, and the defendant resisted those commands. That is the definition of resisting and obstructing. Requesting bind over.
Thank you. So the courts have the opportunity to hear the two witnesses testify at the preliminary examination. That's Officer Shatig and Officer Sergeant Dykins. The standard for preliminary examination is probable cause, the probable cause being the second lowest standard, reasonable suspicion being the lowest standard. And from the testimony of both Officer Shatig and Officer Dykins, Officer Shadig testified that he responded to a assaultive NVOP call upon arrival. The defendant was pointed out to him to further his investigation. He went to the defendant, requested identification with the understanding that he was the subject of the investigation at the time, and that would be the Terry stop, so to speak. That would be the reasonable suspicion the criminal activities afoot. The identification, he was not given identification. He was not given any type of communication that the person was not involved in the matter, but that is the purpose for the detainment, which is reasonable to detain and investigate when that's the person pointed out. Even if later they find out after the fact that the investigation, the person lacks some type of credibility who pointed him out. Sergeant Dykins indicated the same testimony. However, he added that the defendant, and he ID'd the defendant, was bloody at the time. So that changes things a little bit because that strengthens the investigation to go, and then that the defendant's intoxicated based on his experience. And then the detainment occurred. They wanted to detain him. They wanted to ID him. And then there was a resistance of the identification, first of all. And then second of all, the resistance of the officers in placing him in custody for detainment purposes, which led to what appears to be the I don't want to be arrested versus you're arrested or detained. The strength and leverage was talked about to being used in concerns to that matter. At a probable cause level, I find that probable cause has been proven by both officers' testimony for both counts requested. That's the date, which is July 24th, 2024. The venue is the city of Lansing, Ingham County. The location is 2211 Risdale Avenue. Identification was made by both Officer Shadig and Sergeant Dykins. And then the offense, the elements of the offense is in count one as it relates to Nicholas Shading, the officer who was in the Lansing Police Department in full uniform, identified as full uniform, and the defendant knew or had reason to know that Mr. Shading was investigating at the time an assault and or MDOP. The defendant did assault, batter, wound, resist, obstruct, or oppose Mr. Shading's identification requests, and then the eventual fray that led to the arrest and the actual arrest itself. That's in count one. In count two, I will also bind over on the second officer, Sergeant Darren Dykins, as also being a part of the sergeant in the Lansing Police Department. The defendant knew or had reason to know was performing his or her duties. That is the investigation of the assault. There was no identification made. And it appears from Sergeant Dykins' point of view that there was a misidentification, or at least identification was given that was not, that they had to confirm. And then later it was confirmed that a state ID was used for a different type of identification of Mr. Chapman. The identification in court was made. And then that led to So that in and of itself is an opposing the lawful investigation of the assault or MDOP from a bloody and intoxicated individual. And then that led to he becoming a witness to some of Officer Shaydig's resistance and opposement. So I will bind over as charged on both counts. The count 1 is bound over as charged. Count 2, the added or amended count 2, it'll be the added count 2, is bound over as to Sergeant Dykens. For this probable cause hearing at a probable cause level, probable cause has been proven by location, offense, venue, ID, and date, and count 1 and count 2. The 4th offense notice will follow to circuit court. And so, Mr. Chapman, your time in district court is done. This has been bound over on 2 counts. 1 count of the previous charge, 2 counts. Count 2 is the amended charge or the added count 2 of resisting and obstructing as it goes to Sergeant Dykens. Anything else for the record in docket 24-01991, Ms. Wilson?
Half the people, thank you.
Mr. Abbott.
Your Honor, I ask the court to correct the date of offense to July 4th, not the 24th.
July 4th, that's fair. This is the date of offense is listed by both witnesses as July 4th, 2024.
Correct,
Thank you.
yes. And can we get a transcript? Yep. Thank you.
So, and I'll indicate the examination was held on today's date. And we added a count 2.
Thank you.
We're all set, Mr. Abbott.
I think Peterson, I have officers here.
Cool.
No.
Good story.
I do not have anybody on the larceny because they've moved and retired, so I'd be requesting adjournment, but I'll leave you to your argument. Okay. Okay, well, Peterson's in custody and I've had officers for a while on him, so
Okay,
I'll
yeah,
have my
officers for Thompson.
I'm saying what.
So do you want Peterson brought
Peterson,
up?
please, yep.
And then we'll,
And
and
then we
then
can do
we
Thompson.
go back, we can do Thompson.
Hey, Cass, can I go with officers? and
Sure,
Peterson's
I
going
think I'll
next?
take a
Thank
quick
you.
break while Megan's getting Mr. Peterson. So I think we have Peterson next. He's got two files. Which file did you want to call first?
If we can call the larceny from a motor vehicle, that'd be great.
Okay, so that'd be 1752. So we're on the record in docket 22-01752. That is People of the State of Michigan versus William Peterson. Will the parties please introduce themselves to the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Abbott.
Good morning, Attorney John Abbott for Mr. Peterson. He's standing to my right.
And sir, you are William Peterson, is that correct?
Yes, sir.
Thank you. This is the time set for a preliminary examination on this file. Ms. Wilson, how we proceed?
Thank you, Your Honor. I received both my subpoenas back for my subpoenaed witnesses. One of them is a retired detective. The other one was no longer at that address. That is my complaining witness. I did make contact with him last night and he gave me his new address and advised that he was wanting to participate. My notes here indicate that back in March of 2023, the defendant failed to appear for the charges. So I think that it's appropriate here to grant an adjournment considering the delay that was caused by the defendants or inability to get out subpoenas.
All right. I did, Mr. Abbott, your response.
I'd ask for dismissal, Your Honor. They're unable to proceed today.
All right. I do have a failed to appear March 17th. And a bench warrant and bond forfeiture were issued. And then we didn't pick up the defendant for April, May, June. Looks like this was reset July 2nd for today's date. So you, Mr. Peterson was on, or the defendant was on, was absconded. I do find good cause. I do find that an adjournment is warranted in this file, and I will grant the adjournment since we have a new address for the new witness. So I'll grant the adjournment. Adjournment on the case. And of course, the 21-day period has been told or is non-existent because of the bench warrant status that the defendant was placed on for 3 months. So I'll grant the adjournment and we will reset the preliminary examination for the complaining witnesses subpoena and testimony. That seemed to be the major issue. I don't know about the retired detective.
I have not asked around to see if he's still in the area. I plan on doing that.
Right. But all right. But you plan to go forward with the complaining victim?
From what I reviewed right now, yes, that's my intention.
All right, so we'll adjourn, reset the prelim for
August 1st at 9.
reset for August 1st at 9 o'clock for witness testimony prelim. Right, anything else for the record? So this is adjourned to August 1st at 9 o'clock at the request of the prosecutor for getting the correct address. And we've had contact with the victim, so the victim's on board and that they should be answering their subpoena for that date. I would assume. Anything else for the record in 22-01752, Ms. Wilson?
Not on this file, thank you.
Mr. Abbott?
No, Your Honor. I do have an 11:15 with Judge Kennedy, but I can find substitute counsel either here or there.
All right. You let us know. You let us know how that, because I know but I know that you have also a trial schedule. So let us know, and if need be, we can revisit that, but we'll leave it on for that day.
Well, I mean, sorry, I misunderstood. I thought he meant in a couple minutes.
No,
okay.
no, that's for the August 1st date.
Got
Is
it.
that
All
correct,
right.
Mr. Abbott?
Oh, I was looking at the wrong date. I'm fine on August 1st.
Okay, so there's no worries there. All right.
I'm worried about too much.
May I ask a question?
Sure.
Mr. Abbott, we did not get an appearance on this file. The last thing we had was your office did an ex parte motion to withdraw when the warrant issued. So just as a record.
So you might have to
keeping
follow up
matter,
with an
we just
appearance.
kinda
I'll
needed an
follow.
appearance.
Right.
I'll file an appearance. I didn't realize there were 2 cases this morning until.
Right, and you withdrew on this case once the bench warrant was
I'll
issued.
get back in.
All right.
Thank you, Mr. Abbott.
And then we are on the record on the second file, which is docket 23-02320. People of the state of Michigan versus William Peterson. Parties appearances for the record. Ms. Wilson.
Abigail Wilson for the people.
Mr. Abbott.
Good morning, Your Honor. Mr. Peterson stated, am I right? John Abbott representing Mr. Peterson on this case.
All right, and sir, you are William Peterson, is that correct again? All right, thank you. This is the time set for preliminary examination in this matter. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I do have Officer Brown present here today. I had also subpoenaed Officer Meaton. I did have some communication with him previously where he indicated that he was working nights today and was hoping that it would be pushed to a later time. I told him that wasn't going to happen. He's not here. I don't know why he's not here. I'm ready to proceed with Officer Brown.
All right, so Officer Brown is here and the people are ready to proceed to start the prelim. Any response of Mr. Abbott?
No, Your Honor, we're going to come back on the first anyway, so hopefully if we have to adjourn due to needing another witness.
Then we'll adjourn to that date.
Works for me.
All right, so do you want to take the witness
I would
testimony?
prefer to, yes. Mhm.
All right, so we'll call, so understanding there may be an adjournment since one of the witnesses, there may be a conflict or for whatever reason, but the people are ready to proceed to prelim. So we will start the prelim today and then entertain any type of reset later. There is a motion for sequestration. The court will follow, so the court will invoke the motion for sequestration and leave it to counsel to let the court know if there's anybody that should not be listening to somebody else's testimony. And then Ms. Wilson, you may call your first witness.
Thank you, Your Honor. The people call Officer Ella Brown.
All right, Ms. Brown, I'm gonna have you state your first name and last name and spell them both for the record.
Ella Brown, ELLABROWN.
Please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury? All right. Go ahead and have a seat. The microphone is for recording purposes, so please project as best you can. Ms. Wilson, when you're ready.
Thank you, Your Honor. Officer Brown, where do you work?
The Lansing Police Department,
And what's your job title?
police officer.
Can you describe your general duties?
I respond to calls for service in the city of Lansing.
Okay. And were you working as a police officer on March 21st of 2023?
I was.
And during March of 2023, about how long had you been a police officer?
About 3 months.
Okay. And those 3 months, were those all in the city of Lansing?
Yes.
Okay. Now, on that March 21st date, did you conduct a traffic stop near Perkins Street and Dakin Street?
I believe it was Perkins and Bench, but
Perkins and Bench?
Yes.
Okay. Is that in the city of Lansing?
yes,
Ingham County?
yes,
State of Michigan?
yes.
And what prompted that stop?
The vehicle that I was following didn't have a license plate.
Okay. And how did you initiate the stop?
I initiated my overhead lights on my patrol vehicle.
And did the car come to a stop?
Yes.
And what happened after the car came to a stop?
The driver got out of the vehicle. I was with a training officer at the time and we instructed him to get back inside the vehicle, at which point I made contact with him.
Okay. And when you made contact with him, were you able to determine that person's name?
No.
No? Okay. Did you get a good look at him?
Yes.
Would you recognize him if you saw him today?
Yes.
Can you point him out and describe, or sorry, is he here in the courtroom?
Yes.
Can you point him out and describe what he's wearing?
He is right there wearing a gray or a white undershirt.
Okay. Your Honor, I'd request that the record reflect identification.
Any objection to the witness identifying the defendant for purposes of prelim, Mr. Abbott?
No objection. Thank you.
Without objection, the witness has identified the defendant for purposes of preliminary examination.
Thank you, Your Honor. So after you approached and made contact with him, what happened?
I asked if he had his ID on him and he said that he did not.
And what happened after that?
I asked him to get out of the vehicle and detained him.
Okay, and when you got him out of the vehicle and detained him, what was the purpose for that detention?
Because he didn't have his ID on him while I was operating a motor vehicle.
Okay, and at that point, after detaining him, did you search him?
I did.
Did you find anything?
I did.
What did you find?
What I thought was meth.
Okay, and do you recall where it was on his person?
His front right jeans coin pocket.
Okay, and can you describe a bit what the substance looked like?
It was a white powdery substance in a sandwich baggie that was folded up, or a plastic baggie that was folded up.
Okay, and about how much was in there?
I do not recall.
You do not recall? Would reviewing the report refresh your recollection?
And let the record reflect that the attorney is showing Mr. Abbott the report for being used for purposes of refreshing the witness's memory. You may proceed.
Thank you. May I approach?
You may.
Thank you. Officer Brown, if you can go ahead and give that a read silently to yourself. Once you're done, flip it over and let me know. And did reading that report refresh your recollection?
Yes.
And do you recall about the amount that was in there?
Yeah, it didn't register on the scale.
Okay, but did you see something in the bag?
Yeah, there was residual.
Residual, okay. And after you found that, did the defendant make any statements?
He said he forgot about that.
Okay, and did he clarify what he meant by that?
I didn't ask what he meant, but
okay,
it was in close proximity to me finding me.
Okay, and before you actually found that baggie, did he say anything?
Not to my knowledge. Oh, he said that he had swallowed meth.
Okay.
Or ate it.
Okay. And what did you do with the baggie that you found in his pocket?
I put it in a latex glove for security purposes until I could finish the investigation on scene.
Okay. I have nothing further, Your Honor.
Cross-examination, Mr. Abbott.
Thank you. Are you the person that weighed the bag?
I don't recall if it was me or Officer Meat and my training officer. I know that he wrote the supplemental report for the actual testing.
Yeah, but you put the bag on the scale and it was 0.0.
Yes.
And you're not the person that did the true narc test?
No, sir.
He was arrested for driving without a license.
Yes, sir.
Thank you, Your Honor. No further questions.
Any redirect, Ms. Wilson?
No, Your Honor, thank you.
May this witness be excused from the people.
You may, Your Honor,
From
thank
the
you.
defense. Okay, Ms. Brown, thank you for your appearance. You're all set.
Thank you, sir.
Any further proofs today, Ms. Wilson?
No, Your Honor, at this time, the people will be requesting an adjournment in order to get Officer Meat's testimony.
And that's your understanding, Mr. Abbott?
Yes.
All right. So we will continue the preliminary examination for Officer Meaton testimony. And that would be, that'll be on the same date, right? I think that was in August.
August 1st, I believe, was the date. Sure. Yep.
Okay,
Yep.
August 1st at
9.
All right, so this is set for continuation of the preliminary examination for Officer Meaton's testimony. And this will be set with the other file on August 1st at 9 a.m. Anything else for the record in docket 2302-320, Ms. Wilson?
Not for the people.
Now, I've noticed on this file that we started the prelim, so it doesn't matter.
Okay.
Yeah, but we started the prelim. Is that your understanding, Mr. Abbott? We'll recontinue the prelim at August 1st at 9 a.m.
Yes, sir.
All right. Mr. Peterson, I'll see you on that August 1st date. Thank you for your appearance, everybody.
I'll come talk to you. I'll come talk to you. Okay, thank you.
Am I grabbing Mr. Thompson now?
Yeah,
Yes, please.
Dominic Thompson. Where are you off to now, Mr. Abbott? Anybody, anywhere on this floor?
I think there's one place I have to go.
Yeah.
I think. Maybe somebody else come.
I don't know. You're a popular guy.
Thank you. I'll see you,
Yep.
at least on August 1st.
Yeah, I'm sure I've got something with you before then.
Yeah, I initially thought Mr. Abbott was talking about
I thought he meant right now, and I'm like,
like the
eh.
yes, and Kennedy now, and then I thought, no, he's talking about August 1st. But that wouldn't surprise me because Kennedy runs he's in the annex, isn't he?
Yeah.
Yes, yep.
He's on his own.
Yeah, he's on
his own stuff.
Yeah, whatever schedule he's on
Yeah.
he's on. Yep.
I understand. I mean, I appreciate that. I appreciate the situation. But I just appreciate I'm glad to see your clerk. That's it. Thanks, officer.
I'm not coming till 1:30.
So I don't think that we can accommodate.
Yeah, that's fine.
Can I have your notes for wherever we just read?
Yes.
Oh, wait, we haven't finished yet. Never mind.
That made a lot of sense. I'm really glad you know.
And then let me write the number on the top of this one because we got two.
Thompson waving.
Yes.
Okay.
Well, yeah.
Okay.
Because you said you had your cross on stand.
Yeah.
Your
Mhm.
officers on
Yep.
standby. Okay, which I assumed as much because there were quite a few involved.
Yes, there were.
Got okay on
All right,
it.
there's
But yeah,
You say we're waiting the next one, Abby?
yes.
No, the next one's waving.
Okay,
Yeah.
thanks. I won't start the paperwork then.
It's not. All right, so it's not a, that's what it's looking like right now. That's what the key offer, right? That's what that's what the key offer. It's not gonna get better. That's the way it's there. Okay. You still. Your Honor, whenever the court is ready.
All right, thank you, Ms. Schroeder. We're on the record in docket 24-00975. That is people of the state of Michigan versus Dominic Thompson. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Schroeder.
Thank you, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Mr. Thompson, who is present and standing to my right today.
And sir, you are Dominic Thompson, is that correct?
Yes, sir.
All right, thank you. This is the time set for a preliminary examination today. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. It's my understanding that the defendant is going to be unconditionally waiving his right to a preliminary exam. The people also unconditionally waived their right. It's my understanding in speaking with defense counsel that the offer that was relayed is that the defendant can plead to 2 counts of CCW. I believe that's counts 1 and 2, if I'm remembering correctly, at pretrial and circuit.
And is that a fair statement, Ms. Schroeder?
That is, Your Honor, and as the court is aware, and as prosecutors are aware, Mr. Thompson has some other matters in other counties. So as soon as I know what judge he is assigned to, I will hopefully be able to reach out to that new APA, and we'll get something rolling, because it looks like there's a plan here to hopefully get him on the road towards rehabilitative programming.
All right, so may I inquire of your client of his waiver of the preliminary examination, Ms. Schroeder?
You may, Your Honor.
Mr. Thompson, you understand you have a right to a preliminary examination today. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime is committed and the identity of the person who committed that crime. You are represented today by Attorney Aaron Schroeder, and she would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It's my understanding it's your wish today to waive your right to a preliminary examination today. There's been an offer placed on the record that you would plead to counts 1 and 2, and then the others would be dismissed. That was placed on the record. Is that your understanding, Mr. Thompson?
Yes, sir.
Is it your wish today to waive your right to a preliminary examination and have this case can continue to circuit court where negotiations would continue?
Yes, sir.
All right, Ms. Wilson, do you also waive the people's right to preliminary examination? I believe you already said that.
I did, Your Honor, and I will reiterate our waiver.
All right, I find the waiver of the preliminary examination to be knowing, voluntarily, and accurately made. And I will present the documentation for counsel's signature.
No worries, don't worry about it. No worries. Let's see where.
Ms. Wilson, there's also no contact order.
It's not a no contact, it's a bond violation. I believe the basis of the bond violation is actually charges in another county.
All right.
So I have no issue with just getting rid
Dismissing
of
them.
it.
And that would be my
All
request,
right.
Your Honor.
All right. So we'll go ahead and dismiss the PA 53s for, because, and I believe those cases are already bound over.
They're already in circuit,
Yes,
that's correct.
That is correct, Your Honor. And you need to- John, I keep forgetting that there's now a place for you guys to sign.
Yeah,
it. Yeah.
Thank you. All right, so I'm in possession of the document, the bind over documentation signed by all the parties. The examination was waived on today's date, which is July 19th, 2024. It's my understanding as a part of this, there are 2 bond violations, conditions along with this file based on other, this is out of jurisdiction arrests that have been bound over. So Ms. Wilson, how are the people proceeding on those two bond violations that have been received?
Thank you, Your Honor. My understanding is that the bond violations are the basis of underlying charges in another county that are currently in circuit. The people have no objection to a dismissal of those violations.
Is it, and that's your understanding, Ms. Schroeder?
Yes, Your Honor, that is, and those two, like, as Ms. Wilson indicated, those are pending in circuit court, I believe, in Clayton County right now. Yes. So no objection to the dismissal.
All
Thank
right.
you. I should say that. Details.
I go writing, I write too much and then they get confused.
Talk too much sometimes.
Yes. All right, so I will sign the documentation. Is there anything else to come to the court's attention before I sign that the examination was waived on today's date? And I continue jurisdiction to circuit court, Ms. Wilson.
Not for the people, thank you.
Ms. Schroeder.
Now for the defense, thank
All
you.
right. I will sign the documentation to that effect. Mr. Thompson, your time in district court is done now. You'll be on the circuit court, which is the trial court in this matter. You'll get your next date from your attorney, Ms. Schroeder. All right, sir. All right. Anything else for the record in 24-00975, Ms. Wilson?
Not for the people.
Ms. Schroeder.
Now for the defense.
You're all set, Mr. Thompson.
Yeah, I can actually, hang on a second. Can I have a minute just to give him a piece of some discovery? Because the thing is, it's gonna be hard to get to Eaton County or E. Clinton, whatever.
Either.
Any.
Make a copy.
Yeah, my writing's all over. Do you mind if my writing's all over it? Here, I'll just take this staple out and hand it to you. I can always make another copy at my office.
So Ms. Wilson, we'll see you
And
this
the
afternoon at 1:30.
That's correct, and I believe Mr. Pfeiffer will be here as well.
All right.
Oh, fun.
And then Mr. Schroeder, I'll see you this afternoon too.
Yes, Your Honor, and I will be bouncing around a little, because I got some stuff with Judge Buchanan as well.
No,
All right.
it was adjourned because.
We know where to find you.
Yep, exactly. There you go. So like I said, it's a little jacked up, but there you go. All of them. All right, thank you. And
Wendy,
a copy
you
of your
you
bond
jinxed
violation
us.
is in there,
I think
too.
he's adding charges this
You're welcome.
afternoon, so.
On which?
Oh,
case?
Sorry.
Hang on.
Murphy.
With regard to.
Oh, okay, yeah.
All right, so we're on the record in docket 24-01792. That's people of the state of Michigan versus Kevin Murphy. Will the parties please introduce themselves to the record? Mr. Pfeiffer.
Yes, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Mr. Silverthorne.
Good afternoon, Your Honor. Dwayne Silverthorne from the Office of Public Defender on behalf of Kevin Leandre Murphy, who is seated at council table to my right.
And sir, you are Kevin Leandre Murphy, is that correct?
Yes, Your Honor.
Thank you. This is the time set for preliminary examination today. Mr. Pfeiffer, how are we proceeding?
Your Honor, the people have signed a nollie in this matter as they are unable to proceed at this time.
Mr. Silverthorne, is that a fair statement?
Yes, Your Honor.
All right. I'm in possession of a nollie pros or order of dismissal in docket 24-01792. That is people of the state of Michigan versus Kevin Murphy. That has been signed. This is signed without prejudice, sir, which means that people could reissue if they choose to, but for our purposes today, the case will be dismissed. I'm going to send that nollie pros, and I'll indicate that for the record. Anything else for the record in 24-01792, Mr. Pfeiffer?
Not from the people, Your Honor.
Mr. Silverthorne.
Not from the defendant, Your Honor. Thank
All
you.
right, Mr. Murphy, you're all set. Thank you for your appearance.
Have fun.
Ms. Wilson?
Mr. Holly?
Maybe I can bring anybody?
Mr. Holly?
Mr. Holly.
Can you please? It's,
No.
it should be yours.
No. This one's not TV.
Well, she's there.
Yeah, that's not the same.
My guy sees.
Hey, the grant funding, you know, just have fun.
Yeah, you hide behind that.
100%.
Thank you, Mr. Pfeiffer. Thank you, Mr. Silverthorne.
Well, happy gaming.
01841. That's people of the state of Michigan versus Terrence Hawley. Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson for the people.
Mr. Austin.
Good afternoon, Your Honor. Jared Austin appearing on behalf of Mr. Holly. He is present with me at council table.
And sir, you are Terrence Hawley, is that correct?
Sir.
All right, thank you. This is the time set for a preliminary examination today. This is a continuation of a previously started preliminary examination. Ms. Wilson, how are we proceeding today?
Thank you, Your Honor. If the court recalls, at the last hearing, we had 2 officers testify. The court granted me 1 adjournment to try to track down my complaining witness, who, as I stated previously, was homeless and we were not able to find him. Those attempts have not been fruitful, so I'm prepared to make my motion for bind over today.
All right, that's your understanding, Mr. Austin. The people are going to rely on the proofs that that have already been admitted. And they will not be calling any more witnesses today. That's your understanding?
Yes, it is.
All right. So without any further proofs and the people rest, and Mr. Austin, does the defense rest today?
We do, Your Honor. We'll rely on the evidence presented.
All right. By motion for bind over, Ms. Wilson.
Thank you, Your Honor. Going through the complaint here, we're ultimately, before I get into the facts supporting my request, what I plan to do here is not request a bind over on count 1. That's the unarmed robbery. We haven't had sufficient testimony. I completely recognize that, and we're not pursuing bind over on that. On count 2, the people are requesting an amendment to the language of the offense to eliminate and/or Officer Tony Cena from that offense. Count 3, we would be requesting to follow as a misdemeanor. We would also be requesting an added count 4 of resisting and obstructing for Officer Cena. And then we would also be requesting an added count 5 of receiving and concealing under $200.
That's a misdemeanor.
That is a misdemeanor.
So if I understand and then I'll indicate the motion for bind over for probable cause, count 1 is not being requested. Mm-hmm. Count 2 is being requested for Officer Stelges, who did testify. Mm-hmm. Then we will be striking Tony Cena, correct. Officer Cena, from count 2. Count 3 would be the misdemeanor A and B.
That's correct.
Count 4 would be the added count for R&O, and that would be with Officer Tony Cena.
That's correct.
Just so I get this. And then count 5 would be the misdemeanor R&C, or receiving and concealing. And that is for 200 to 1,000?
Under 200.
Under 200. Mm-hmm. All right. And so that would be your motion to bind over based on the testimony of Officer Stelges and Officer Cena.
That's correct, Your Honor.
Did you want to make an argument, or is that?
I'd like to make just a brief argument.
All right,
for the
you
record.
may.
So we had testimony from both Officer Stelges and Officer Cena. Both testified as to the date being June 19th, the location being in the area of 541 East Edwidge Boulevard, which is in the city of Lansing, Ingham County, state of Michigan. They both identified Terrence Hawley as the individual that was accused on that date and pointed him out in the courtroom. So the elements for these offenses of date, venue, and ID have been met. As for count 2, there's testimony for counts 2 and the added count 4. There is testimony from the officers that they arrived on scene in response to a complaint of a larceny or some kind of theft that had occurred. The complaining witness had pointed out the individual that had done this to the officers. They attempted to stop that individual and he fled. And not only did he flee, he fled into an apartment building and up 3 flights of stairs, I believe was the testimony. Even when he got to the top of the stairs, he was not compliant and resisted the officers in arresting. After he was taken into custody, he continued to resist the officers, and they had to actually take him down to the ground again and use further control. So I think the elements of resisting and obstructing for both Officer Steljas and Officer Sina have been met. The added count fine that the people are requesting is a misdemeanor. We don't really need to get into argument, but just for the record, we do have testimony from Officer Sina under the property hearsay exception that the that there was a phone found on Mr. Hawley's person. That phone was linked to the individual who had called, and that individual did not give Mr. Hawley permission to have that phone. So I think to a probable cause standard, that element has been, those elements have been met as well. Again, we don't really need to show probable cause, but since it is an added count, I'd like to make a record on it.
All right, thank you. Response, Mr. Austin.
Thank you, Your Honor. I know the court is well aware of the standard at this stage, which is probable cause, which is a relatively low burden. However, it is a burden that the people must meet. As it relates to the R&O charges, Your Honor, I don't think there's any dispute that these were uniformed officers and performing of their duties. I think then the question then becomes, based upon the circumstances and evidence and testimony was presented, was Mr. Hawley required to comply with anything they were telling him to do at that point? Certainly they had not witnessed him commit any crime. I think the testimony was they had arrived on scene, spoke to a complaining party and identified Mr. Hawley as being someone who had committed a crime. And at that point, they told him to stop, and then Mr. Hawley took off. So then I think the question that the court is going to have to look at is, was Mr. Hawley under any obligation to stay there or to comply with their demands at that point? I'm asking the court to find that there was not. I'm asking the court to deny the people's motion for bind over on those counts. I think, Your Honor, as it relates to the added count for the misdemeanor receiving and concealing, that is true. They don't have to show probable cause, I don't think, because it's not a felony that's being requested. But my understanding, I think when they're asking to add a misdemeanor count at a preliminary examination, there has to be some finding or determination, I think, similar when a arraigning judge or magistrate would be listening to a swear to. Yes, there was testimony admitted under Rule of Evidence 1102 as it relates to property ownership, control, and so forth, but that does not extend to any type of illegal taking of that property. And the court even stated upon my objection that it would not be considering it substantively in that way. So I think there is insufficient testimony or evidence to bind over on that request for an added misdemeanor count. And again, Your Honor, I would ask the court to deny the people's motion.
Thank you. Response, Ms. Wilson.
Thank you, Your Honor. As to the allegation that the commands were not lawful, I think what we have here is a complaining witness who advised that he had been assaulted and his property had been taken. He points out the individual that had done it. Officers then have a reasonable suspicion that a crime is afoot and that there's this individual is the person responsible for that crime. Under, I believe it's Terry and its progeny, there's an investigative detention that can be made. That is a lawful command that the officers made. Mr. Hawley then resisted and obstructed that command by fleeing. And additionally, he continued to resist and obstruct as he was taken into custody. So I think that the elements there have been met. I think this was a lawful command in the course of the officer's duty. Mr. Hawley clearly had reason to know that they were officers and that he was being ordered to do something as he fled and continued to resist. So I think the elements there have been met. As to the RNC, there isn't a requirement for the property to have been taken by the person that had it. It is receiving, possessing, concealing, or aiding in the concealment of stolen, embezzled, or converted property. There is testimony here today that the individual had the phone in his pocket or not today, sorry, at the last exam, and that he did not have permission to have that. So I think that is sufficient evidence to a probable cause standard for receiving and concealing. So I'd be requesting bind over.
Thank you. So first of all, let's say at the previous preliminary examination, we heard the testimony of Officer, I'm not gonna say his name right, but it's Officer Tyler Steljas and Officer Tony Sina both testified, and it appears that that they testified, and so we look at the at the probable cause standard for a district court preliminary examination. Probable cause being a lower standard. It's the second lowest standard in criminal law, reasonable suspicion being the lowest standard. And we do have some Terry type reasonable suspicion behavior in this that we'll talk about. But I find by at a probable cause level, based on the testimony of Officers Stelgis and Officer Sina, that probable cause is met that this occurred on June 19th, 2024. And the location was it's near or about Edgewood Boulevard in the city of Lansing, Ingham County. It is near, it's near that address. Identification was made by both officers. And then we get to the elements of the offense. I will grant the non-request. So count one is not going to be bound over on the unarmed robbery as not requested for a bind over by the People's State of Michigan. Count two, the R&O as to Officer Tyler Stelgis. He indicated that he was in foot pursuit of Mr. Hawley, and his request was to have him stop so he could do the investigation concerning the what they were called out there for, which was some type of larceny or armed robbery. That was the initial request, and that's why the officer is in the part of his investigation. He attempts to detain Mr. Harley as part of that investigation, and Mr. Harley runs, and then he runs into an apartment. But the running and Mr. Stelgis testified that he was in full uniform and was able to see. So at a probable cause level, I'll bind over count two as Mr. Hawley did assault, batter, wound, resist, obstruct, oppose, or endanger. Oppose probably being the flee and elude part of it. On foot, Officer Tyler Stelgis, police officer of the Lansing Police Department. He was in full uniform, and the defendant knew or had reason to know he was performing his or her duties. At that time, there was a testimony indicating that he was part of investigation of an armed robbery or unarmed robbery at the time. So that's as to count one. That's as to count two. Count one is not being requested to bind over. Count three is a misdemeanor, and that will follow. Count four is in regards to the resisting, obstructing of the added count two, which is Officer Tony Sina. Officer Sina indicated that the same as Officer Stelgis, that he was in the lawful investigation of the armed robbery, and then he was part of the foot chase. He became part of the foot chase of that situation, and that he was part of the arrest. He found the cell phone that was found on the person of Mr. Hawley, and that was part of the investigation. Was a cell phone of the complaining victim at the time was found. At least that's there was an indication. I believe that rises to a probable cause level for the RNC. It certainly doesn't. It certainly doesn't rise to the level beyond that. But I'm comfortable binding over. So I'm comfortable binding over on counts 2 and 4 as felonies, as location, offense, venue, ID, and date are made as to Officer Tony Senya, and did assault in that Mr. Hawley did assault, batter, wound, resist, obstruct, oppose, or endanger Officer Senya, a Lansing police officer that the defendant knew or had reason to know is performing his or her duties. That's count 4. And then count 5 is a misdemeanor. I do think I've heard enough enough notice is given, especially since we've had a couple of weeks since the this was said on June 19th, but there have been some time to see if the complaining victim, the person of the unarmed robbery, is going to show. But I find that counts 2 and 4 are bound over, and the third offense and any misdemeanors will follow. So I'm going to bound over on count 2, the added count 4 of R&O, and then the misdemeanor count 3, and count 5 misdemeanors will follow. Of course, the supplement, the notice will follow. So, Mr. Hawley, your time in district court is done now. You're bound over on counts 2 and the added count 4. The examination was held on June 19th, 2024, and July 19th, 2024. And it was found by probable cause evidence that we will amend or add count 4 R&O as to Officer Sania. And then we'll add a count 5 of RNC under $200. Those are misdemeanors, but I want to make sure the information reads correctly on the complaint. Anything else for the record before I complete the bind over documentation on 2401-841, Ms. Wilson?
Not for the people. Mr. Austin indicated that the defendant might have a request of the court. I'm not sure if that wants to be addressed.
All right, Mr. Austin.
Thank you, Your Honor. I'll inquire of that of Mr. Hawley momentarily. If I could just briefly address bond, Your Honor.
You may.
Your Honor, given that the most serious charge in this matter, the 15-year felony, has not been bound over, I would ask the court to consider reevaluating Mr. Hawley's bond, either in the amount or the form. His case, this particular case has only worsened numerically in that he has more charges than what he did have, but he's only been bound over on 2-year charges and misdemeanors. The far more serious charge has been dismissed, and I would ask the court to consider granting him some relief on his current bond.
Thank you. Ms. Wilson, any response to the reduction in bond? The 15-year felony was not bound over as to count 1.
That's correct, Your Honor. In reviewing Mr. Hawley's bond, it appears that his strangulation file that was before the court last time was bound over. He's got a $50,000 cash surety. On this file, he currently has a $10,000 cash surety, and it appears that he has a bond denied on a simple assault. I don't know what that is, but he also has a hold out of Clinton County for $1,400. Given the number of cases that he has opened, the assaultive nature and some of them, the flight from justice, I think that this is appropriate. He is a habitual offender. I think it's appropriately set.
All right, thank you. I'm gonna modify bond, but I'm not gonna modify bond by a lot, but I do believe that he is not. And I want to take a look at this file as a whole on its own. It is a $10,000 cash surety. I'll modify it and reduce bond to $8,000 cash surety in regards to the not requesting a bind over on the 15-year felony. So we're left with 2 years and 293 days, and the offense notice. The $8,000 cash surety is the reduction in bond for the request. Anything else, or did you want to inquire of your client if he has anything to address the court, Mr. Austin?
Mr. Hawley indicated to me in our last discussion he did. I will leave that to Mr. Hawley.
All right, Mr. Hawley, is there anything you'd like to say to the court? Your time in district court is done. I have yet to sign the bind over notice. Is there anything you'd like to say to the court?
Let me see. I had never been to this court where I got listened. There's no evidence.
Did you have a question on bond, Mr. Hawley?
Not on bond. I don't think me and him see eye to eye.
All right, well, you can formally request for a new public defender. However, I think you only get one. You get this public defender. They don't allow you to public defender shop. You can seek, and you can on motion of your own in circuit court, because I'm not going to have jurisdiction over this case. You're in circuit court now. You can represent yourself. And then that's up to the judge in circuit court. And most likely the judge is going to assign somebody, probably Mr. Austin, as a backup attorney, so he can answer any questions. But you'll be going forward on your own in pro per in the situation. I don't think it's a good idea. I think it's a horrible idea, but you can do it on your own if you choose.
And before Mr. Hawley responds, just to place this on the record in response to what the court said, Your Honor. I spoke with my immediate supervisor about this, Mr. Cornish. Mr. Hawley's case as of now will not be reassigned. So the options that were explained to me, as I explained to Mr. Hawley, he can continue with my representation. If he wishes to have me withdraw from the case, that would result in the withdrawal of the entire Office of the Public Defender. And then it would be incumbent upon Mr. Hawley to retain his attorney or his own attorney, or have someone do that on his behalf, or he could motion the court to represent himself. And those would be his current options.
Those would be your options in circuit court, in front of that, and when in front of whatever judge it's assigned.
It's Judge Dragonchuk.
So it's Chief Judge Dragonchuk. So do you understand your options today?
I got my people looking into it, Lord, but
All right.
I'll keep them.
All right, he's going to be assigned, and you're gonna have him, and then if you choose to go a separate route, that'll be at your request. All right, sir. All right, I'm going to sign the motion for documentation for bind over, and you should be all set. Thank you for your appearance, Mr. Hawley.
Thank you, Judge.
Thank you, Mr. Ross.
You guys need the transcript?
Yes, please.
Were you able to write small enough to get all that in
What's
there?
that?
Were you able to write small, get everything in?
All I did was R&O, add count for R&O to Officer Seaman. So yeah, however you want, so just so they recognize the easiest way for
I think if
them.
you sign both this
All
and the
right.
bind over, we'll send that up to
All
30
right.
too, just in case they have any questions. At least that way.
Right.
I'm sorry, Mr. Ross, I'll get. Oh, got a paperwork up here. Would you please be so kind to give that to Ms. Wilson?
I will do just that.
And then Judge, because account one was dismissed, I need to sign the
Denali.
Denali, please. Otherwise, the clerk's office, as you know.
They're very literal, which is fine.
Very
That's
particular
good.
about
Yeah.
that.
You have no earthly idea.
All right, we should be all set on Mr. Hawley's file. And then Ms. Schroeder, are you ready to go on Mr. Wooten?
Yes, Your Honor.
All right. Stay back with the magistrate.
Ms.
Oh, she
Playback
was-
took Mr. Holly back
All
to
right.
jail. She should be here momentarily.
No, we're fine. I was just making sure. I forgot Mr. Holly had to go back. All right, so we're on the record in docket 21-01095. That's people of the state of Michigan versus Ansel Wooten. Will the parties please introduce themselves to the record? Ms. Wilson,
Abigail Wilson for the people.
Ms. Schroeder.
Thank you, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Mr. Wooten, who is present and standing to my right.
And sir, you are Ansel Wooten, is that correct?
Yes, sir.
All right, thank you. This is the time set for a preliminary examination today. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I found out while we were on our lunch break, actually, that my officer that was subpoenaed, Officer Freeman, might still be out because her wife just gave birth. I did just receive a text message confirming that she is out until August 26th. I'd be requesting a good cause permit.
All right. And then Ms. Schroeder, that's your understanding, and what is your response?
Your Honor, I understand, I can appreciate what is going on here to a certain extent. However, we had a good cause adjournment before on this file. I do realize we had an adjournment at our request last week due to family concerns to Mr. Wooten, but he is here. He is traveling a significant distance from Detroit. He has children. I don't know why this wasn't known before, if this is the same individual who keeps on being subpoenaed, that only now the third try, that now we have this issue. I appreciate the situation from the prosecutor's perspective, but I would still be moving at asking at this time for the court to dismiss.
Thank you. Well, we each have one adjournment.
If I could just
Okay, Ms. Wilson.
make an additional record, Officer Freeman was here on that first date.
All right.
Oh.
So that was Officer Freeman, who is the officer on record. but we each have an adjournment. We have a waiver of the 21-day and adjournment at request of defendant on July 9th, and then we have a request for an adjournment for just cause for purposes. The waiver of the 21-day rule has been made. It was made on July 9th. So we'll set this for one last time, okay? We got each one. We each side has one. So next time somebody's either gonna bind over or not. So I will grant the request for an adjournment. The waiver of the 21-day rule has been waived as of July 9th, 2024. And we will set, so the adjournment is at the request of the prosecutor. And we'll reset. And I'm gonna indicate here, we'll reset a last time.
We also get a 1:30 on that if possible, because he is traveling.
Yeah, I think, well, let's see, it'll be an afternoon.
Okay, yeah.
Well, let's see what date we get. Yeah.
How long is the officer expected to be?
After August 26th.
That should work well with our schedule.
It should.
Because
I
we
mean,
don't have a lot before
I mean,
August.
I think our option last I knew was August 22nd, so.
Right.
That's gonna have to cancel 60 days. Actually, more towards 80.
So August. So do we have anything on the 29th or 30th?
Not in the afternoon.
We don't have anything in the afternoon for the 29th or 30th?
And the 29th, stuff. Oh, no, I bought the stuff for the Sheldon Thompson.
Which one is Mr. Thompson?
Oh, that's Calvin Thompson. That's Mr. Johnson's case that we just adjourned because Mr. Johnson has COVID. He's got
We
two
can put
files.
this with that, yeah.
Okay.
Yeah, we can put that with, that's two prelims, but those are the two prelims that
Two
we
prelims,
set
yes.
today.
Mhm.
Let's put that on that since we, even if that goes, it won't be,
I don't
it won't
think
be an
it should be super
afternoon.
long,
Yeah.
no.
So we'll adjourn to August. Date and time?
August 29th at 1:30. And this is the cause.
No, this is just, he waived the 21-day rule as of last time, so that we don't have to adjourn for good cause. So we will set for August 29th at 1:30. Now that each side has requested an adjournment, and we'll see if the Officer Freeman is here on that date. Anything else for the record in 21-01095? Ms. Wilson,
Not for the people.
Ms. Schroeder.
Not for the fence, Your Honor, thank you.
All right, Mr. Wooten, we'll see you on that August 29th date.
I appreciate it, okay. Appreciate it. Not happy. There's not- Judges made his ruling. We gotta go with it.
All right, we're all set. Thank you for your appearance today.
Thank you. Thanks. Mr. Wooten, can you get your notice? All right.
Yeah.
He had a problem with his time this morning.
Yeah, it's timing is everything, but he's fine.
He'll be
I-
fine.
he-
He's just
he-
irritated. I get
That date is seared in his brain to be here or not.
Well, he's shown up to the last few times. The
Right.
only time he didn't show up, he already told us why. So,
Right.
I mean, he's got kids, he's coming from Detroit. I get it.
Yeah, it's frustrating.
It's frustrating.
It is.
I would appreciate that.
I thought they
get
were
it.
his sister's kids.
Yeah.
I thought they were his sister's kids.
His sister's kids and his own.
And his kids,
Right.
okay.
So he's got his own, I think she's out now, but at the time last week, she
Right,
was
she was
in.
in.
And she ended up with not only his kids, but hers.
That's why.
He doesn't want to come to Detroit anymore.
He doesn't want to come to Lansing ever again.
No,
He has no desire ever to be in Lansing again. I can guarantee it at this point.